I'm attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate, securities, and business transactions law firm. Today, I am going to explain risk factor disclosures in SEC reports and private offering documents. For a more in-depth discussion on this topic, please see my blog that was published on November 18th at securitieslawblog.com. A risk factor disclosure involves a discussion of circumstances, trends, or issues that may affect a company's business, prospects, operating results, or financial condition. Risk factors must be disclosed in registration statements under both the Securities Act and Exchange Act. In addition, risk factors must be included in private offering documents where the exemption relied upon requires the delivery of a disclosure document, and it is highly recommended that they be included even where such disclosure document is not required. Although smaller reporting companies are not required to include risk factors in their annual Form 10-K or quarterly Form 10-Q, they may do so voluntarily, and we recommend that such risk factors be included at least in the annual 10-K. The careful crafting of pertinent risk factors can provide leeway for more robust discussion on business plans and future operations, and can satisfy a wider range of SEC concerns regarding existing financial and non-financial matters, such as a potential default or inadvertent rule violation, just to name a few examples. Risk factors are so important because together with safe harbor language regarding forward-looking statements, they can provide protection for forward-looking information contained in a document, such as plans and expectations that do not pan out as expected or intended. Risk factors warn current and potential investors as to the risks of either purchasing or continuing to own a company's stock. As the securities of smaller reporting companies are often high-risk penny stocks or thinly traded, and such companies are often in the business development and growth stage of their corporate life, disclosing such risk factors is fundamental. The protection afforded by risk factors in forward-looking statement disclaimers stems from the bespeaks caution doctrine. The bespeaks caution doctrine refers to a line of judicial case law holding that statements of future forecasts, projections, and expectations in an offering or other disclosure document are not misleading as long as they contain adequate cautionary language disclosing the specific risks. Section 21E of the Exchange Act, enacted as part of the Private Securities Litigation Reform Act of 1995, codifies this doctrine for qualifying issuers. Section 21 provides a company with a safe harbor defense in securities litigation challenging forward-looking statements. Among others, companies that issue penny stocks may not rely on Section 21E, but they still may rely on the bespeaks caution line of case law. To avail itself of the safe harbor protection, the forward-looking statements must be accompanied with risk factors that contain meaningful cautionary language that identifies important factors that could cause actual results to differ materially from those projected. So getting to the actual drafting. Risk factors are one of the most often commented on sections of a registration statement. Items 501 and 503 of Regulation SK include the requirements for the disclosure of risk factors. Item 503 of Regulation SK requires concise, logically organized statements of the particular risks involved in either the company, industry, or the offering being made by the company. The statement should be categorized and appear in order of importance under each category. Item 503 requires that the disclosure of risk factors in a registration statement be included in the beginning, immediately following the summary section, or if there's no summary section, immediately following the cover page. Item 501 requires that the risk factor section be prominently cross-referenced by page number on the cover page of the registration statement. Most companies comply with this rule by using bold or italics or a larger font size or a combination of all of this in order to comply with that rule. Risk factor disclosures cannot contain countervailing or offsetting language. A company cannot explain away the risk. Like many areas of securities laws, the SEC only gives broad guidance on risk factor disclosure, trying to avoid pigeonholing or boilerplate language. The SEC requires the reporting company to make relevant risk factor disclosures that are germane, concise, and written in plain English. The risk factors should be written as of the date on the report in which they are contained, regardless of the period of the financial statements contained in that same report. Each risk factor must have a heading and adequately describe the risk being disclosed, and such headings should be bolded, italicized, or both. Each risk must be concise and focused on a single material risk. The risk must be easy to read and written in a way such as to highlight the most important information. As mentioned above, the SEC requires that the risk be written in plain English. Over the years, the SEC has published many and updated many manuals regarding plain English writing, but the basic guideline requires that there be short sentences, definitive, concrete, everyday words, using active voice, tables or bullet point lists whenever possible, no legal jargon or highly technical business terms, and no double negatives. Okay, moving on to categories of risk factors. In general, risk factors pertain to either the company, the industry, or the investment or offering being made. Company risks are those specific to the company, such as particular restrictive covenants in contracts, reliance or dependence on a concentrated source, or a history of losses. Industry risks are particular to the industry of the company, such as technology or manufacturing or textile, or commonly in today's marketplace, cannabis. Investments or offering risks are those specifically tied to the security or trading market of the company's securities, such as a lack of liquidity. The risks included in each category should be organized in the order of materiality and importance. The common broad areas of the risk factor disclosures include an absence of operating history, an absence of revenues, an absence of profits, an accumulated deficit, high degree of leverage or debt, dependence on a single or small number of products or suppliers, customers, manufacturers, or markets, dependence on key personnel, dependence on particular financial resources or sources of capital, early stage of product development, competition, adequacy of production or distribution, technological factors such as possible obsolescence, capital needs and the lack of adequate current or future financing, a concentration of voting control in management or others, the absence of a trading market or a thinly traded low price market, litigation, government regulations, foreign operations and the effects of foreign regulations or export laws or currency fluctuations, labor matters, intellectual property matters, restrictive covenants in contracts or off-balance sheet arrangements. And this is not a full list, this is just the most common. Risks that apply to any company should be avoided. For example, a general statement that an economic downturn would negatively impact a company should not be included. On the flip side, a concise statement that a particular economic change, such as a reduction or increase in the federal interest rate or a particular risk associated with that change, could be included. Specific examples are encouraged. And as always, competent legal counsel should be utilized in crafting SEC reports and offering documents. I'm Securities Attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about any of the information we've just covered, visit securitieslawblog.com or contact me directly. Inquiries of a technical nature are always encouraged.